case briefs, and so much more. LSData's got what you're looking for.
In 1964, the Supreme Court of the United States heard the case New York Times Company v. Sullivan, which centered around the question of whether public officials can automatically sue for libel if someone criticizes them. The case began when L.B. Sullivan, a public official, sued the New York Times and 4 individuals for publishing an advertisement that he claimed contained false statements about him. The case aimed to determine the extent to which the First Amendment's protections for speech and press limited a state's power to award damages in a libel action brought by a public official. The New York Times argued that the First Amendment protected their right to criticize public officials, and that the advertisement was not intended to defame Sullivan. The court ultimately ruled that the Constitution prevented public officials from suing newspapers for defamation, unless the newspaper knowingly made false statements or showed reckless disregard for their truth. Sullivan failed to prove actual malice, and the Alabama court's decision violated the First Amendment. The case was returned to a lower court to determine general or punitive damages, marking a significant victory for press freedom and the right to criticize public officials under the protection of the First Amendment.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.